Good morning, everyone. I am Rifat S. Sambulawan, and now we are going to talk about the international law and justice. Among the greatest achievements of the United Nations is the development of a body of international law, which is central to promoting economic and social development as well as advancing international peace and security. The international law is enshrined in conventions, treaties, and standards. Many of the treaties brought about by the United Nations form the basis of the law that governs relations among nations. While the work of the United Nations in this area does not always receive attention, it has a daily impact on the lives of people everywhere. The General Assembly as a forum for adopting multilateral treaties. The General Assembly is composed of representatives from each UN member state and is the main deliberative body on matters relating to international law. Many multilateral treaties are in fact adopted by the General Assembly and subsequently opened for signature and ratification. The Legal Six Committee assists the work of the General Assembly by providing advice on substantive legal matters. The committee is also made up of representatives from all United Nations member states. The General Assembly has adopted several multilateral treaties throughout its history, including First Convention on the Prevention and Punishment of the Crime of Genocide, the International Convention on the Elimination of All Forms of Racial Discrimination, International Covenant on Civil and Political Rights, International Covenant on Economic, Social, and Cultural Rights, Convention on the Elimination of All Forms of Discrimination against Women, United Nations Convention on the Law of the Sea, the Convention on the Rights of the Child, the Comprehensive Nuclear Test Ban Treaty, the International Convention for the Suppression of the Financing of Terrorism, International Convention for the Suppression of Acts of Nuclear Terrorism, Convention on the Rights of Persons with Disabilities, and last one, the United Nations Convention on Contracts for the International Carriage of Goods wholly or partly by sea. I have here the other examples of the General Assembly. We have here the United Nations Convention on the Law of the Sea. It says in the part 4 of this convention, Article 56, rights, jurisdiction, and duties of the coastal state in exclusive economic zone. In the exclusive economic zone, the coastal state has a sovereign rights for the purpose of exploring, exploiting, conserving, and managing the natural resources, whether living or non-living, of the waters superjacent to the seabed and of the seabed and its subsoil, and with regard to other activities for the economic exploitation and exploration of the zone, such as the production of energy from the water, currents, and winds. Letter B, the jurisdiction as provided for in the relevant provision of this convention with regard to the establishment and use of artificial islands, installations and structures, marine scientific research, the protection and prevention of the marine environment. Letter C, other rights and duties provided in this convention. In exercising its rights and performing its duties under this convention in the exclusive economic zone, the coastal state shall have due regard to the rights and duties of other states and shall act in manner compatible with the provision of this convention. Optional Protocol to the International Covenant on Economic, Social, and Cultural Rights in 2008. In many areas, the legal work of the United Nations has been pioneering, addressing problems as they take an international dimension. The UN has been at the forefront of efforts to provide a legal framework in such areas as protecting the environment, regulating migrant labor, curbing drug trafficking, and combating terrorism. This work continues today as international law assumes a more central role across a wider spectrum of issues, including human rights law and international humanitarian law. We have here the International Law Commission. The International Law Commission was established by the General Assembly in 1947 to promote the progressive development of international law and its codification. The Commission is composed of 34 members who collectively represent the world's principal legal systems and serve as experts in their individual capacity, not as representatives of their governments. They address issues relevant to the regulations and relations among states and frequently consult with the International Committee of the Red Cross, the International Court of Justice, and UN specialized agencies depending on the subject. Often the Commission also prepares drafts on aspects of international law. The international humanitarian law encompasses the principles and rules that regulate the means and methods of warfare, as well as the humanitarian protection of civilian populations, sick and wounded combatants, and prisoners of war. Major instruments include the 1949 Geneva Conventions for the Protection of War Victims and two additional protocols included in 1977 under the auspices of the International Committee of the Red Cross. The United Nations has taken a leading role in efforts to advance international humanitarian law. The Security Council has become increasingly involved in protecting civilians in armed conflict, promoting human rights, and protecting children in war. We have here the International Court of Justice. The International Court of Justice, which has its seat in The Hague, is the principal judicial organ of the United Nations. The primary United Nations organ of the settlement of the disputes is the International Court of Justice, also known as the World Court. It was founded in 1946. Since its founding, the court has considered over 170 cases, issued numerous judgments, and issued advisory opinions in response to requests by the UN organization. Most cases have been dealt with by the full court, but since 1981, 6 cases have been referred to special chambers at the request of the parties. We have here the tribunals. After the Second World War, the Nuremberg and Tokyo trials address war crimes, crimes against peace, and crimes against humanity committed during the Second World War. The This applies as well to the 3 courts established by the states concerned but with substantial UN support. The Special Court for Sierra Leone, 2002, the Extraordinary Chambers in the Courts of Cambodia of 2006, and the Special Tribunal for Lebanon on 2007, sometimes referred to as hybrid courts. They are non-permanent institutions which will cease to exist once all their cases have been heard. The International Criminal Court. The idea of a permanent international court to prosecute crimes against humanity was first considered at the United Nations in the context of the adoption of the Genocide Convention of 1948. For many years, differences of opinions forestalled further developments. In 1992, the General Assembly directed the International Law Commission to prepare a draft statute for such a court. The massacres in Cambodia, the former Yugoslavia, and Rwanda made the need for it even more urgent. The International Criminal Court, or the ICC, has jurisdiction to prosecute individuals who commit genocide, war crimes, and crimes against humanity. It will also have jurisdiction over the crime of aggression when an agreement is reached on the definition of such a crime. The ICC is legally and functionally dependent from the United Nations and is not part of the UN system. The cooperation between the UN and the ICC is governed by a negotiated relationship agreement. The Security Council can initiate proceedings before the ICC and can refer to the ICC situation that would not otherwise fall under the court's jurisdiction. The court has 18 judges elected by the state parties for a term limited to 9 years, except that a judge shall remain in office to complete any trial or appeal which has already begun. No 2 judges can be from the same country. So that's all. Thank you.